Good morning, everyone. My name is Sean Huggett, as Cherie has said, and I'm an information governance consultant with a company called CyberCrowd. We're an information risk and security consultancy organization, and we work with Softcat to support their customers with governance, risk, and compliance. Now, I in particular lead their data protection practice, and as I'm sure you can appreciate, we're spending a lot of time right now helping Softcat's customers prepare for GDPR. I'm very pleased to have been asked to host this webinar this morning, to have the chance to talk with, as Cherie has said, Egress's Chief Operating Officer, Neil Larkin. The aim for this webinar today, and for myself in particular, is to go through and discuss some of the points that Neil made in his very timely blog, which has been published on the Softcat blog and GDPR Hub, and the title of that was How to Make Every Email GDPR Compliant. So, Neil, good morning. Thanks for joining me and inviting me here today to discuss the issues raised in your article. Before we get into the nuts and bolts of GDPR, I think it would be good if you could introduce Egress. What did you start out to achieve, and how has that evolved during the history of the business?
Thanks, Sean. So Egress was actually set up just over 10 years ago as an encryption vendor, and we were kind of looking to solve a problem around how you share confidential information securely via email, and encryption kind of was the solution to that. I think in that time, though, that the market has really kind of changed in terms of, encryption doesn't solve a lot of the real problems that are out there today, but does play a part in securing that content. So particularly with the changes now, with all of the, and with talk today around GDPR, there's a lot of drivers now that mean that we have to evolve as well as a technology business.
Yeah, that's interesting. So a lot's changed in those 10 years from a technology and also from an information and personal data perspective. So, how have you seen data protection compliance change during that period? I imagine you've seen a big old transformation, have you?
Yeah, so obviously, the Data Protection Act has been in force for some time, and I think one of the common misconceptions is that GDPR is a huge step change from that. While it does put a lot of different things in place, I think there's been increasing awareness of security concerns, and if you look at the number of fines and things like that are available and have happened over the last few years, I think the general awareness has been increasing, but with GDPR, we're seeing that, again, another big step change in terms of how every organization is brought under that umbrella.
Yeah, no, I see that as well. I'd agree with that. So I know from our correspondence that you're always talking to Egress customers in your role as COO, and you'll be talking to them about, their use cases and emerging challenges and threats and what have you. Now, for organizations that are exchanging and sharing personal data, whether it's with other data controllers or with their data processors, what are the biggest issues they identify as they're preparing for GDPR?
So I think, again, there's no kind of magic bullet to solve all these things, but I think the one thing that's very consistent is, being able to prevent a data breach still remains a very complex challenge, and there's lots of parts to that can aid you in doing that. I think with kind of GDPR, it obviously adds a great deal more sort of onus on the organization. So, you've now got to kind of retain control of that data in every kind of scenario. So whether you're sharing it, whether you are storing it locally, and the third parties you can communicate with, you need to kind of understand that. And then on top of that, you've now got things like subject access requests and sort of reporting that is required as part of GDPR. So I think, we're seeing organizations maybe quite scared about this whole approach and sort of not really understanding it. And there's a lot of organizations coming to us in kind of panic mode where they're realizing the May date is looming and how do they sort of get on with this. There's lots of relevant articles. You can go to Softcat actually to get more detailed white papers around all of this. But on the screen now is just sort of some of the articles that we believe technology can assist with, and actually we're sort of focusing on some of the ones that are very different to what the Data Protection Act had originally required you to do. So things like, an individual having the right to gain access to any content you may hold on them, the right to erasure, And actually then the sort of things like Article 32, where actually you've got to put more procedures in place, so, recommendation of encryption, things like that.
Yeah, no, absolutely. I think although data subject rights exist in the current law, as you say, I think awareness of those data subject rights is growing and is going to be much higher in anticipation of and after GDPR. Now, clearly, one of the ways that organisations share a lot of personal data, in fact, it's the most common in the work that we do, is with email. And I think one of the misconceptions that we see in organisations is that if you've bought an email platform, whether it's on-premise or more likely these days a cloud-based or software-as-a-service platform, that it comes with security baked in out of the box. And we're commonly explaining to customers that it isn't that straightforward. So in layman terms, would you be able to explain what the data security risks are inherent in using just an out-of-the-box email system in a standard configuration?
So I think you're absolutely right. A lot of standard mail platforms offer a great deal more security than they maybe did a few years ago. So, enabling things like TLS and various things like that to kind of secure email in transit is obviously good practice. There are obviously other risks around, there's attacks in various forms now, so it could be as simple as hacking or sort of man-in-the-middle attacks on email. And then the things that we're focusing more tend to revolve around the sort of user-centric approach. So, someone missending an email to the wrong person, encryption is not going to solve that problem. It's not going to address any of the issues that are there, and we'll kind of come on to that in a bit more detail in the next few slides.
Yeah, that's a really interesting point, and you can put all of the security measures in place, but ultimately user error is going to be an issue that you have to deal with. And I think we all have experienced being sent emails intended for someone else, or dare I say, even in my case, and it's embarrassing when I have done it, given what I do, sending an email to the wrong person, particularly with autofill in Outlook and what have you. But it could have a really damaging impact on an organisation, particularly if it contains personal data. It's effectively a data breach. So, why do you think the sending emails to the wrong recipient has become so common? And what, if anything, can technology do to help prevent it from happening?
So I think that, there certainly won't be a single person on this webinar, or I'd be very surprised, who hasn't done this and sent an email to the wrong person. In fact, we did some recent analysis of this, and not everyone owned up to having done this, or certainly owned up to sending an email containing sensitive information to the wrong person. But the stats sort of say that 35% are saying that they have done this. Sort of 50% actually say they have received emails in error. And I think typically, when these events have happened, it's because products like Outlook make it very easy they suggest users that you may want to communicate with, and the most common scenario would be that actually you get the wrong first name and you don't notice that you've sent an email in the wrong context to someone else that you do regularly communicate with, but copied in someone else, or the content is for the wrong client, those kind of things. So there's lots of things that we believe, and I think from our perspective, this is a really easy message for us to kind of look to address. So if we're looking at the ways that we look at this is, advances in technology have made kind of AI and sort of machine learning allow us to do some really clever stuff here, and you can look at historic interactions, you can look at historic behavior of users from a machine learning perspective, and then this, can start giving users guidelines on when we believe they are maybe about to make a mistake. So engaging with the user and hopefully preventing a data breach. And, on the slide there's some, it's all around doing things like detecting unusual activity. So it's I may be sending an email to 5 different recipients, but one of them is not normally seen with the other 4 in that context, or it could be that someone's maliciously trying to, they might be sending emails at certain times of day that are out of their normal pattern, or it could be sending it to a single Hotmail or Gmail address. So really, there's kind of 2 facets to this. There is the accidental, I sent an email to the wrong person, and then there is the more kind of malicious attack on this.
I understand. So we touched upon there not just accidental sending, but more malicious activity, and clearly security. Whilst GDPR is not about security, security is a big part of the existing legislation. The Seventh Data Protection Principle and the Data Protection Act is about securing data, and GDPR builds upon that. And actually, as you know, Neil, GDPR, the big change is it changes the burden of proof, and it puts measures on data controllers to demonstrate accountability. And one of the ways that they have to demonstrate accountability is to implement appropriate technical and organizational measures. Now, a lot of our clients get confused by that because they're looking to be told exactly what to implement, but because it's risk-based, organizations have to take account of the sensitivity of the personal data they've got and apply what they consider to be appropriate to the risk. So the flexibility is there for organizations to adopt suitable technology as well as processes and procedures. So in your experience from talking to your customers, what factors should shape the measures that organizations should take to protect the personal data when they are intending to share it?
So I think, again, it's as you say, it's selecting something that is appropriate for the information that's being shared. So central bodies such as the ICO obviously do recommend encryption, and as an encryption vendor, obviously we understand the importance of where encryption should be used. But again, as I mentioned at the beginning, encryption doesn't solve a lot of these issues. But what it can do is, if you are sharing information with the right person, then security and processing, as referred to in Article 32, will actually ensure that you are meeting a lot of the standards. I think. On top of that, though, you've got to obviously have appropriate controls around access and things like that. You need to have proof that you've done what you should have done. So, having good auditing and controls in place to report on the steps that you have taken to do this. So, audit visibility is very, very important. And I think, if you look at a lot of the more legacy technologies that have been in place, they don't provide a lot of this proof or tracking methodology that is required as part of GDPR.
Yeah, I couldn't agree more, Neil. I think the ability to audit and demonstrate compliance is going to be incredibly important, because what might be within compliance one day might fall out of compliance the next day, depending upon the nature of the data, how you're sharing it, and even your risk appetite. But one thing I wanted to follow up on before we go into that in a bit more detail is automation. So you mentioned automation in one of your earlier questions, and we hear a lot about automation in the tech press. It's quite a buzzy expression, and not everyone understands how it can be applied in the real world. So in your article, you talk about organizations introducing automation to override human error. So what does that look like in the real world, Neil?
So I think the first step with all of this is, and again, GDPR does mandate this, is actually understanding what data you have within an organization. And there's a huge set of requirements around that. So, and there's lots of technologies that are available that allow you to kind of analyze all of your data silos and find out what kind of things are in place. Then you kind of need to understand, what the business needs to achieve. So, there are ways to kind of put things like, policies and machine learning and DLP rules in place. But again, before you can do any of that, you really need to understand what you're dealing with. And so we spend a lot of time at Egress on that piece is how do you find the information that you probably should be securing? How do you know where it sits across all of your environments? And particularly with email that we're talking about today is, do you understand with both clear text and encrypted content what information is contained within that? So, there's a very big piece of understanding that takes place, and obviously with CyberCrowd, you're very familiar with that. The training and the kind of general understanding before you even think about putting technologies in place play a very big part in that. And then I think, in terms of automating it, it's really about, helping the user make the right decision. And I think that's really the thing we focus on. It's not necessarily just encrypting everything or just preventing anything from leaving the organization. It's really about how do you assist the user to make the right decision and make it, dare I say, almost part of their general day-to-day work without becoming a typical security product that people want to try and bypass and actually don't enjoy using.
Yeah, no, I absolutely agree. And I think you've raised a really powerful point there, which is that I think most organizations and individuals that are responsible for GDPR in organizations absolutely understand that technology alone is not going to make them GDPR compliant. And if anything, there's a bit of a fatigue, I think, among organizations in the private and the public sector for vendors who are claiming that their products and solutions is the answer. But what they do recognize, and I think this is absolutely valid, is that the right technology can help them meet their obligations in some areas. It can help them identify personal data processing that presents a risk. It can help them manage the risk. It can also help them enforce policy and process and implement controls that are there to protect them in the event that the policies and the processes don't work from an organizational point of view. And I think actually technology can help businesses turn business policies into something tangible and actionable. So how do Egress customers use your technology and go about taking what's written in a document and is their way of working in their business policy and turning it into something that's actionable and real within their organization?
So there's a lot of interpretation of the new requirements, and I think every type of industry interprets them in a different way and seeks a lot of assistance on this, as we have as a business. To be perfectly honest, it's understanding what are the systems you have in place, what are the technologies that you use, and then look at how you do that. And of particular interest is when you do share, and again focusing on email just for this particular discussion, is how do you ensure that any information you share with third parties is appropriately secured. So again, encryption may play a part in that, but what do you want to do about things like restricting access? And if you do share highly sensitive information, should it be something that the end user, the third party, can then take control of and download and print and things like that? So you may want to restrict all of that. And then on top of that is, if you do send something to the wrong person, being able to revoke and also prove that you revoked access to that particular information. And so a lot of the things that we find our customers do is they want to control the data they've shared even after it's left their boundary. So there's lots of things, and we can revoke access to email even after it's been sent or at any point after it's left the organization, and have an audit trail to show that it's been revoked, to show that maybe no further access has been granted to that information, and then even track down to where users are accessing or attempting to access that content. And this can all be applied to different classifications of data. So I think one of the biggest things we haven't really touched on today, but it is a big part of this, is when you start understanding your information, classification is a kind of an interesting way to start solving this. So you start across your organization, you start understanding what your data and what the sensitivity of that content is. So is it PII? Is it just internally confidential? And again, you can apply different sort of release mechanisms depending on those classifications.
Yeah, no, I understand. So Elizabeth Denham, the Information Commissioner, and Stephen Eckersley, her deputy, have been giving a lot of speeches recently, and they say that GDPR is about three things. It's about transparency, it's about accountability, but it's as much about giving data subjects greater control over their personal data. And that's clearly enshrined in the data protection principles and in a number of the articles of the instrument itself. Now, your blog on the Softcat GDPR Hub touched upon three articles in particular, 17, 18, and 19. And what these do is they mandate situations where an organization might have to do things in line with a data subject rights request. And that's people like you and me, Neil. So we're natural persons, we're data subjects, and we might want to exercise our rights in certain cases. And there's two sides to that. There's the human challenge associated with having an employee go away and put effect to those subject rights, primarily searching through data or identifying where it is. And then there's the technical aspect of that, interrogating systems you've got, but actually using technology to help make that easier in some cases. Would you be able to elaborate on that technical challenge for organizations in trying to control access to data once it's been shared with third parties, please, Neil?
Yeah, so again, it comes back to this ability to really have controls in place, which will allow you to track every piece of data across the organization. So it does start internally, because actually a lot of the GDPR requirements, and again, there's not a huge amount of focus on this at the moment, but I may be sharing PII information to to a third party inside my organization, or I may be sharing that content externally. And I think, it's really about the proof and the tracking and the, if there is a breach, or it's actually if an individual comes and requests that, I need to know where data linked to that individual is at any particular point. And actually, I need to maybe pull it back. I may need to prove that it has been removed from all systems in place. So it's about really just understanding where your information is, and from a third-party perspective, just being able to say, right, I don't really care whether the information is inside my organization or external to the organization. I have the same controls in place to ensure that I can monitor and understand what's taking place at that point.
I think that monitoring and assurance is a really important part of accountability, and it's probably a good time to think in a bit more detail around how Egress can help with that, because one of the challenges that I see in a lot of our clients is that there's almost a view, certainly at the executive level, that the 25th of May is a bit of a finishing line, that if we can get our house in order, a bit like a project, that we're going to be fine thereafter. And as of course you know, Neil, it's just the start. The 25th of May is when GDPR begins, and it's being ready for GDPR is less of a project with a finite timescale, more of an ongoing program. There's a life cycle around it, and you need to keep things under review, and that requires ongoing assurance and auditing, and it requires organizations to have metrics and be able to identify where data is going, and then be able to go away and work out why data is going there, and then identify issues and apply risk management procedures to that, even be able to identify whether the risks to rights and freedoms of data subjects are sufficiently high to necessitate a data protection impact assessment. And when you think about the data breach obligation, there's 72 hours for organizations to report a data breach that presents risks to rights and freedoms of data subjects. And in that 72 hours, you have to make an assessment as to A, whether or not a breach has occurred, and then secondly, whether it's affected personal data, and then thirdly, whether it's reportable. So having access to a monitoring and a reporting platform, I think, is going to be really important for organizations. And with that in mind, I'm interested, how does Egress support its clients in this capacity? So when they're looking to analyze and report on the personal data they're processing, they're sharing, whether by email or by other means, how can you help them ensure that they've got a good view of that and be able to report and analyze on it, Neil?
So we've kind of developed some fairly recent technologies in this space, and what they kind of allow you to do is to retrospectively look into information that, or in this example today, email, the historic mail, and be able to actually identify where individuals' information actually resides across an entire email infrastructure. And actually, it's kind of this sort of forensic analysis that is very, very important, because you need to also be able to prove not only that you found that content, that you've done something with it and you've actually done the appropriate requirements aligned to GDPR. And I think all of this is needs to be aligned to the way the industry is moving as well. So most, I should suspect, in the next 3 to 5 years, most organizations will move their mail platforms from on-premise to cloud if they haven't already. And again, obviously, we're seeing a huge adoption on this. So these technologies need to work across a myriad of different mail platforms and need to understand mail of all types, whether it's clear text, standard email, or it's encrypted email. You need to be able to understand where subject-related information actually resides, and actually be able to comply with all of the various legislations in that way.
I think subject access requests are going to be a challenge for organizations. Some organizations and some commentators are already suggesting that we can expect to see a rise in the volume of subject access requests, really for two reasons. One, because the right to charge a £10 fee, not that every organization has done that, but the right to charge that will be removed under GDPR. And secondly, given the publicity around GDPR and the campaigns like the one that the ICO are running at the moment to increase awareness are ongoing in advance of and after May, it's likely that we as data subjects are going to become more aware of our rights. And I think email in particular presents a real challenge as far as subject access requests are concerned. For example, I had a client who recently had a subject access request from a former employee and they were after information in emails during a period of time that they've identified will probably require them to go back and look at over 7,000 emails, which is going to have quite an impact on their organization. So I think email and subject access requests is going to be challenging. And what do you think some of the particular challenges are going to be if you do hold personal data in not only the body of emails, but also in attachments? And how do you think organizations can avoid this becoming that big burden on their resources that I referred to?
So I think there's a lot of organizations that are rightly so quite worried about this, and I think it almost has that effect of something like the year 2000 where everyone was kind of petrified about what was going to happen. I think this is slightly different in that most organizations in certain industries would have had to adhere to people being able to do this before, and those organizations we've spoken to are probably more worried than any, because actually they know how much work it has been involved in the past to actually facilitate a subject access request. If it's for 1 or 10 people, it was a very significant impact on the business. So, with the prospect of these going to crazy numbers of thousands of requests, even a day, could be in certain industries. I think organizations are looking for technologies that make this process easy, kind of with sort of out-of-the-box reports that allow them to analyze and understand that content. And most importantly, with all this, it's not necessarily about just retrieving the document. It's actually where there are references to that individual. So it's actually the content rather than a specific document or a specific email. It's actually where does that content reside on any sort of mail platform, in attachments, in emails, maybe on file storage platforms, or even cloud sharing platforms. Again, all of these will apply if someone does execute the right to a SAR on their information.
It's a really important point, as you say. The right is to information, not to document. So being able to identify the document in which the information resides is the first step. I think then the challenge, as you yourself have said, Neil, is analysing the information that's in there. One, to determine whether it's personal data. Second, and really importantly, to identify if it refers to any third-party data subjects and identifying what you need to redact, because if it does refer to them, you shouldn't be sharing their personal data unless they give their consent to it. So that first step is identifying what you've got, and the second step is analysing it. So it's a really, really important point. Now, one of the other things that I think is a hot topic for this conversation, but it's also, given the time that we've got available, probably the last and most appropriate, therefore, topic to end on. And that's around Egress itself as a data processor and a data controller. So I work with lots of organizations, and one of the things we do early on is identify their data processors, and you typically have payroll organizations. You might also have people that are providing outsourced HR services to them and what have you. But given that most organizations are moving to cloud-based technologies where a lot of their data is being shared with or being used by platforms upon which they rely, whether it's an HR platform or a finance platform, a lot of IT providers and application providers sit among their most important data processors. And clearly that would include Egress. You yourselves would be a data controller in respect of the personal data that you process here, primarily of your employees and your business contacts. And you'll also be a data processor to your clients. So perhaps we could finish by you covering what steps Egress are taking to ensure that you're going to be ready for GDPR, please.
So I think we're in the same boat as every organization. There's a certain element of fear of the amount of work we've got to do to ensure we meet the deadlines of compliance. We've engaged third parties, companies like CyberCrowd, to assist with, understanding that we are heading in the right direction, because I think that's one of the things that is very important. Is you need guidance, you need assistance on all of these things, because there's a lot of experts out there that know how to take a business through the process. We're also demanding a lot on our suppliers as well. So obviously as a cloud provider, we have a lot of third-party cloud providers that we contract with, plus, as you said, HR systems. We have systems for payroll, for accounting, things like that. So again, we have to, there's a lot of questionnaires, there's a lot of requirements that we are requesting from our suppliers as well. So I think really the thing about all of this is, even though we are a business in, very much in the security space, software technologies are not going to solve, they're not the magic bullet to solve all of these things. So actually, there's a huge amount of training going on. There's a huge amount of advice required, and actually, it's about, I think, showing good progress ahead of those sort of go live dates.
Yeah, I think that's the right approach, Neil. Thank you. So thank you for your time. I appreciate that. I think it would be a great opportunity now to pass back to Cherie so she can invite questions from people that have kindly joined us today on the webinar. Cherie.
Thank you, Sean. Thank you, Neil. As we said, you can submit your questions via the Q&A tool or using the chat function, and then Neil and Sean will be addressing those as soon as possible. So we've got a question already in from Richard. He asks, isn't the right of processing linked to a specific purpose?
Yep, so I'll pick that up. It absolutely is. So the lawful, in order to process personal data, there needs to be a purpose for it, and then there needs to be a lawful basis for it. So if we were to look at the governance requirements around GDPR, you should be looking at the data protection principles that are set out in Article 5, and they start with fair, lawful, and transparent, and they go down to specific, explicit purpose. So irrespective of the tool you're using or the technology you're using, if you shouldn't have the data in the first place and you don't have a lawful basis for it, and you aren't processing it fairly, which means being transparent and providing data subjects with privacy notices, you're not going to be compliant no matter how good your security is. So you're absolutely right. You need an explicit purpose, you need to be transparent about it, and you need a lawful basis for processing.
Great, thank you. We've also had another question around the right to be removed. Claire asks, if someone has made this request and you remove them entirely from your records, how do you prevent new employees from contacting that person in the future? As a sales business, this is quite a challenge for them.
So I think, Neil, I'll start with that and then hand over to you to share your experience if you're happy. And I think a suppression list is going to be very important for organizations. And I think one of the things that customers often say to me is, how can we forget data subjects and remember we've forgotten them? And it does seem impossible to do both at first glance, but actually in reality, I think there's a few things to bear in mind. The first thing is the right to erasure is not absolute. So you only have to delete someone's details if you don't have a lawful basis for retaining and processing that data. And typically it's going to apply where someone had given you consent and then they subsequently withdraw their consent. But you will need to retain their data for the very sole purpose of being able to demonstrate, A, that you've deleted it, and secondly, to put it on a suppression list and stop people contacting them. And the lawful basis for that is most likely going to be legitimate interest, your legitimate interest to ensure that you meet your obligation, or potentially the other lawful basis might be it's a legal requirement on you. So being able to retain that is going to be important, but then stopping people calling out to it will require a suppression list. It will require you to have a section in your platforms that ensures that sales executives are aware that they shouldn't contact them, and you need to start thinking about these features in your CRM and other platforms. Neil, you clearly will be affected by this, and you yourself have a sales organization. How are you approaching it out of interest?
Yeah, so again, we've had varying views on this topic, and I'm like you, I'm not sure there is absolutely a carte blanche answer to it. What we have been told, though, is that there's actually a very big difference between holding information on an individual and actually retaining audit information that user once existed, and I think those two need to be separated in terms of the operational piece and the actual data on those individuals. So yeah, you're absolutely right. A kind of suppression list is what we've been advised to do from our perspective, as we obviously have millions of users on the system, and there will be some that will want their accounts removed or things like that. So the account can be removed, but actually the audit trail to say they once existed is very different.
Yeah, and I think that, Cherie, just to close on that point, if we go back to the first question, I think it was Richard's, that comes back to purpose. So it might be the same record, but what Neil said there is that there's the same record but two processing purposes. The first purpose was probably for sales and marketing, If that consent is withdrawn or the use of that is objected to, you can't process it for that purpose. But the purpose of creating an audit trail or meeting your obligations is separate, and it'll have a different lawful basis, and you'll be able to retain it for that reason. But I think most organizations are looking at suppression lists to ensure, you know, I know Softcat well. I work with a number of your key people, and I think that you're looking to have that capability built into your own CRM to ensure that you don't contact people that have said, look, not only don't contact me, but I don't want you to have my details. So I think it's the right approach.
Yeah, great, thank you. We've got more questions more around the systems. Jane asks, how do we revoke an email once it has been sent?
So that sounds like one for me. So it is obviously only possible if you have encrypted the email. So, you know, I think that probably everyone has seen the useless functions in Outlook where you record an email and it doesn't really do anything apart from highlight that you've probably sent something you didn't want to. But actually with Egress, we actually have the ability to revoke access to an encrypted email. So because we have real-time key requests, essentially if I revoke an email and the third party tries to open that email, it will request a key and get a denied and will no longer be able to access any of the content. So it's really about staying in control of emails at that point.
Yeah, great. And on this related topic, what email systems and file storage platforms does Egress work with?
So currently we work with all of the kind of Microsoft standard environments, and we also fully support Gmail, G Suite. In fact, we're doing some very significant enhancements to the G Suite platform in the next couple of weeks. And then we actually also support any other mail platform from a gateway perspective as well. So if there are, I'm not sure if there is anyone out there still on Lotus Notes or some of the other older systems, then we do support those as well. But primarily our focus is on the two main players, I would say, which is Microsoft, either on-premise or 365 and Google G Suite.
Great, thanks, Neil. Another question from Mark is around backups and deletions. He asks, what technical solutions are available for data backup deletions when a subject requests this? Backup seems to be currently nearly impossible to ensure data is removed from the backup environment.
Perhaps another one for me. A very good question, I think. So one of the things that we are able to do is to locate where that content is. But currently, we don't have a solution to go into a third-party backup. So we can actually say where that information is, but you would need to then use the third-party backup system to do the deletions. That's not to say we're not looking into that area and looking to ways to improve that. Because we are API driven, it means that we can interface with other third-party systems. But very difficult challenge to solve at the moment, I would say. And again, we've had different varying reviews as to how actually backups should be treated under GDPR as well, as to whether they actually do need to have the same content deleted, given the type of access that is there.
Great, thank you. And just going back to our previous questions around processing, and Daniel asks, for sales companies or companies that have hundreds, tens of thousands or 100,000 existing contacts, how are they going to go through the process of getting consent from every one of those individuals, and how reliant can they really be on legitimate interest?
So we could probably spend a good hour or a day or longer answering that question in detail. In that it depends on a number of factors. I think the first thing is that consent isn't the only lawful basis upon which you can rely. Yes, you can rely on legitimate interest. It actually does say in one of the articles of GDPR that direct marketing is a legitimate interest. But I think, and it's a good point on to what extent can you rely upon it. The answer is it depends. It depends upon the marketing and sales activity you're performing. And if you are going to rely upon legitimate interest, you need to do what is referred to as a balancing test. So in short, your legitimate interests must not be outweighed by the interests, rights and freedoms of data subjects. So my advice is any organisation that does intend to rely upon legitimate interest, it should document that it's gone through the balancing exercise, and there is good guidance available from the European regulators on how to perform that. The other thing is that you should also take into account particularly if you're doing electronic marketing, you should also take into account the wider legislative framework. We have a regulation here in the UK called the Privacy and Electronic Communication Regulations 2003, which date back to the 2002 e-privacy directive, and that basically lays out the requirements for marketing to organisations by electronic means. And in short, if you are cold calling or telephone marketing, then you can effectively rely on legitimate interest and objection or a form of opt-out. If you're doing email marketing to individual subscribers, you will need their consent to do so, or you can rely upon what's referred to as soft opt-in, where if you have sold an individual a product or service or negotiated with them, you can subsequently assume that they have opted in, the soft opt-in, and given their consent for you to market to them about similar goods and services, but you have to give them in the first point of contact and every contact thereafter the opportunity to unsubscribe or object or opt out. So it's quite a complex area. I think the starting point is to analyze your data, to identify whether it's existing customers or prospects and look at the quality of that data, and then identify whether you can evidence consent and also think about the type of marketing that you're going to perform.
Great, thank you, Sean. We'll take one last question, Neil, which is goes back to the integration of Egress. Is there a Gmail integration that's not dependent on the G Suite?
Yes, so it's basically we have a Chrome extension. In fact, as I say, there's a new iteration of that coming out in the next 2 weeks, which is going to have some very cool functionality, which will do in-browser encryption, decryption. So it doesn't need to be G Suite. It can be any variant of that, and as long as you're using the Chrome browser, we can do some very interesting stuff there. But again, contact your Softcat account manager who will be able to give you more information on all of that.